Hello neighbor, I'm Robert Burns and welcome once again to another edition of Sound Off Louisiana. And today we will be covering the contradictory hearing that took place this past week on Tuesday, October the 22nd of 2024 with regard to Phil Preis's motion for a new trial on the Stanford matter. And at the end of this feature we'll give you all of the prior links for each of the features that we did with regard to the Stanford trial. I think by now anyone is aware that my sentiments on that trial were essentially that it was a joke. There was no compelling evidence presented throughout the trial, and I think any objective observer would have to make that conclusion, particularly one with any bank examination experience, as I happen to have 6 years of, and I can tell you that a number of other bank examiners who have followed the sound off features we've done are in disbelief that this trial could have even taken place. But having said that, you may remember that the jury, they said that there was an obligation owed to the investors. However, on the second part of the jury form, they found by 11 to 1, I think the jury was unanimous in saying that a duty was owed, and then it was 11 to 1 saying the OFI did not act recklessly, therefore there was no liability. And let me just say this, there is no question that a duty is owed, okay? What is that duty? It's the duty that Doree Allen clearly outlined when she gave, it was a videotape testimony by way of a deposition. But yes, they have a duty to go in and examine the paperwork, make certain that these were not investments geared for every Tom, Dick, and Harry, and to go through the paperwork and ensure that they had signed off saying that they were accredited investors. That's the nature of the duty that was owed, and the OFI fulfilled that duty, okay? And I'm going to make just a very brief, we're going to get to the arguments that were posed by each side in just a moment, but I'm going to make a very brief analogy. Many of you know I like to use football analogies. Well, picture the OFI as the referees, okay? And they are supposed to officiate a game, keep it fair. That's what making sure the paperwork was in order for them being accredited investors, all right? That would be the role of the officials in this football analogy. What OFI is trying to assert, LSU played Nicholls State earlier this year. Nicholls State actually gave them a decent game, but I think anybody would know that Nicholls State is going to be outmatched, especially coming into Tiger Stadium to take on the LSU Tigers. What Mr. Preis is in essence wanting to argue is that the officials in charge of officiating that game should have grabbed the microphone prior to kickoff even taking place and saying that, look, we have deemed this to be a total mismatch. Not only is Nicholls likely to get completely blown out, but we believe there may be 2 or 3 injuries to result from this game. Therefore, we are calling the game off. We're asking everyone to exit the stadium now. This is a mismatch. I think that's a pretty good analogy, because can you imagine the reaction of the fans if the officials did that? Okay? Nicholls knew the risk. This would be the equivalent to saying the officials of a football game should go and regulate the athletic directors who scheduled this thing. Now you can bet every official knew it was a mismatch. Every fan would know it's a mismatch. But Nicholls knew the risk of a loss, and not only a loss, but a lopsided loss, as it turns out. Nicholls gave LSU a pretty good game. But that's the analogy I'm trying to make, is that OFI fulfilled its duty. And they regulate banks. They don't regulate individuals. This would be like trying to tell those fans at that football game, not going to allow this to take place. Too big of a mismatch. No. If you enjoy seeing the slaughter, which is what typically should have happened, and you enjoy seeing 50-point, 60-point wins, that's your prerogative. And it's just like it's Nicholls' prerogative, knowing that you know, they call them rental wins for these type games, but Nichols knew the risk. They knew the financial benefit to playing that game, and the officials would have no business stepping in trying to say, look, this game cannot take place, okay? And I'm going to just say one other thing. When it came time for the verdict, the courtroom became packed, and it became packed with a lot younger folks. Now, this is probably the future generation that, you know, said, well, we lost our funds. And these folks were a lot younger than the actual victims, of which there would only be a couple on any given day. I'm just going to tell you that if I'm on the jury, that wouldn't have gone over well with me, and I'll tell you why. I'm talking about packing the courtroom. It's, so we had to sit through 3 weeks of this, but you all want to just show up and watch what you believe is going to be a big cake carved up. Never mind all we had to go through. Y'all just feel like, hey, let's just show up and right at the verdict time and look to get it. Never mind going through the 3 weeks that jury had to go through, because they went through some stuff only to get blamed by Mr. Preis for the final outcome of it, which we've already published a feature on. It's despicable that he would do that. But that's my personal opinion, that packing that courtroom was a mistake. I would have had that perception as a juror, that, well, why weren't you here for all the grudgery that we had to go through? And I believe, give me just a second, a guidance, what's his name? I'm sorry, I forget his name now. Daryl Glasper, I'm sorry. He was a guidance counselor at my high school. And I noticed that WBRZ got a quote from a Daryl Glasper, and I would assume that may be the son. I'm only you know, just throwing out a little speculation. But he said, look, the juries they're good people, but they got it wrong. Well, how would you know they got it wrong? You weren't there. You weren't there for any of the testimony, but you're going to show up when it's time for the verdict and emphatically declare they got it wrong. So I realize there's anger toward that jury, both on the part of the victims as well as obviously Mr. Preis. And that's an absolute insult to that jury. That's an absolute insult. And they did not get it wrong. Let me give it two other points before I go into the arguments that were made. We're going to give you a link for an article that was published earlier this month. Ralph Janvey, the receiver for the Stanford fiasco, has the full authority, the Stanford efforts to block the payment to the victims from the TD Bank settlement for $1.2 billion. They're now all out of the way, and the checks are going out. And we're going to give you the article. We'll give you a New York Times article in that regard. The article also talked about that apparently some $700 million worth of claims had already been bought by some hedge funds, where folk got anywhere from maybe 6 to 12 or 13 cents on the dollar. And you know, that's a perfectly legitimate market to have. So now, with it appearing that the investors are going to get approximately, you know, give or take, 35 cents of their claim, give or take. Some investors obviously may regret that, but I guess that goes to how long this thing dragged out as to why anyone, and there's a gentleman in the front of it, first of the article, that will indicate that he accepted $60,000 on a $1 million claim, whereas he would have gotten approximately $350,000. But I want to say two things about that article, or two things that I need to clean up. You may remember we issued a retraction for what was, in my case, mistaken identity with regard to Ms. Angela Shaw Kogut, Angela Shaw Alexander. I had said that she encountered me outside of the courtroom. I issued a retraction on that, and I certainly apologize for that fact. That was not her. The individual whom that was, I have since learned, was Miss Jean Ann Mayhall, and she would be the one who obviously has no use for me and certainly has no use for the reporting I had done on the Stanford matter. So I want to make sure credit is given where credit is due. That would be Miss Jean Ann Mayhall. She did identify herself as representing the Stanford victims, which is what prompted me to Google to try to get a name. That's how I got Miss Angela Shaw Alexander's name. But I still think we benefited from all of that because Miss Alexander, we got to profile an approximate $4 million investment and her strong belief that it should have been covered by SIPC, which I'm not going to go into it, but I think I have authoritatively demonstrated why those losses were not covered, or up to 500,000 of those losses were not covered by FIC insurance. So with those preliminaries out of the way, and I'm not going to spend an excessive amount of time on the arguments that were made both by Mr. Preis and by Mr. Blunt. And one of the key reasons for that is we're going to give you a direct link. Now, for those of you who only subscribe to the YouTube channel, you're going to need to click on the Sound Off Louisiana feature to be able to get both the feature itself as well as an actual opposition memorandum, which the Phelps-Dunbar team drafted. It is 33 pages long. I'm going to highlight some of the material in the opposition memorandum, but I believe it is an incredibly well-written opposition memorandum. It will also give you kind of a chronological snapshot of what all took place during the trial. And that opposition memorandum, in my opinion, speaks for itself. And as I put in the title to this feature, I'm a little bit concerned about the wording that Judge Johnson made as he told the attorneys to, well, we'll get to that in just a second. Very briefly, Mr. Preis said he was going the route of a new trial versus a judgment notwithstanding verdict because he says the judge has the authority to assess the credibility of the witnesses. He's relying on Code of Civil Procedure 1973. There's also 1972, which the judge doesn't have discretion in. That's when a jury finding is clearly in error, and that most certainly is not going to be the case here. So he's relying on 1973, and we'll give you the link for that. It's like a one-sentence Code of Civil Procedure that for which a judge would have discretion, but it's supposed to be in well, you can read it, and we'll highlight the one sentence. In my opinion, this is absurd, so the judge will have the ability to assess the credibility of the witnesses. Mr. Preis argues that the witness evidence versus the oral testimony were completely in conflict with one another. He has stated that the witnesses for OFI were, quote, self-serving and biased, to which Mr. Blunt of Phelps-Dunbar said, well, that's his characterization that these witnesses were that. And in fact, if you look at the opposition memorandum, you're going to see that Mr. Blunt had some rather pointed statements about Mr. Preis and his litigation techniques throughout this trial. They kind of echo what I have stated repeatedly, and that is that he did the testifying. He took snipes at witnesses. It was just, look, I've previously said that it was the worst courtroom performance I've ever seen, and I've observed a lot of trials. So I'm not gonna go into any more because each side took about a half an hour of these arguments. But I do want to focus in for the final wrap-up of this video, and that is the directions that Judge Johnson gave to each of the two. that being Mr. Price and Mr. Blunt. He indicated that he wants, and I'm quoting here, he wants Mr. Price to, quote, marshal all of the evidence for which you believe that either Code of Civil Procedure 1972 or Code of Civil Procedure 1973 that the judge could grant a new trial. I don't know how much more there can be out there beyond the motion itself. Likewise, he instructed the defense to corral everything as to why Code of Civil Procedure 1972 and 1973 would not be applicable. He said that he wanted all of this clearly into the record in order that any appeals court that may look at this after he renders a judge. Oh, by the way, in typical John Johnson fashion, he also said, draft your judgment, and he wants all of this in by this coming Tuesday, which is October the 29th. And so he wanted to make certain that the record is very well documented in order that if there be an appeal of this, any First Circuit decision would have all of the available material in order to ascertain whether Judge Johnson had, quote, abused my discretion, unquote. The reason that wording is troublesome for me is that there's an abuse of discretion would seem to only be possible if you granted a new trial. And I can only tell you that that would be one of the most unbelievable moves I've ever seen a judge make. When you have an 11-to-1 jury verdict, the jury weighed the evidence. The evidence was put up ad nauseum. And the reason I didn't go through a lot of the oral arguments is that they've already been in our prior features, so I don't see much point in rehashing it. But I'm a little concerned by that wording. As most of you know, I believe that the motion for new trial should have been denied right there from the bench. But I am concerned about that wording by Judge Johnson because I'm unaware of any way he can abuse his discretion unless he grants a new trial. And that will just be absolutely mind-boggling. So that's going to do it. I hope everyone has an enjoyable weekend. And again, we will provide the opposition memorandum. You'll see the link for the original filing of the motion for the new trial, which we already covered in a prior feature. But this, in my opinion, should have been an open and shut hearing in which the motion for the new trial should have been denied. And I think this is just dragging on additional taxpayer resources having to defend this matter when it's pretty much indefensible. What I mean by that is the plaintiffs dragging this on and dragging this on, that's what's indefensible. Their acts of doing that. But we've got to continue to shell out money as taxpayers on what has been, the case was pathetically weak. That's all I can say. So folks, I hope you've had an enjoyable weekend, and we will obviously give you whichever judgment Judge Johnson signs, be it to deny the motion for the new trial, or if he grants it, we will provide you with that. You can take it to the bank, that'll be appealed. But once we know that, we will update this feature and let you know his decision. And then therein, assuming that it is denied, the motion for the new trial, that will begin the clock to start ticking on any potential appeal of the entire trial, which Phil Price may opt to launch. In my opinion, that is beyond throwing good money after bad, but he and his clients are the ones that have to make that decision. So thank you once again for your dedication, and we look forward to seeing you again real soon for another Sound Off Louisiana feature. Thank you so much.